ఆప్షన్స్ రావట్లేదా? స్క్రీన్ షేర్ చేసింది ఎవరా? అవునా? హలో సార్, విక్రమ్ సార్. హలో బషీర్ సార్, గుడ్ మార్నింగ్.
Sir, very good morning, sir.
Sir, if you don't mind, you please disable participant annotation, sir, please.
Okay, sir, fine.
Okay.
Sure, sir.
Okay.
Sir, shall we start, sir?
Sir, I am ready, sir.
Sir, principal sir, shall we start, sir?
We can start, Vikram. Go ahead. Hello, Vikram. Hello. Vikram. Hello, Vikram.
Sir, actually, what is Bashir, sir? Sharma, sir.
Yeah, Vikram ji. It's audible. No issue. Go ahead, please.
బాగా పనిచేస్తుంది కదా, తీసుకో.
Good morning to director, principals of group of institutions, all heads of group institutions, faculty, and outside faculty, all the participants. Very good morning to all. I would like to welcome today's speaker, Professor Kk Bashir. He has done his BTech and MTech in Computer Science and Engineering in JNU Hyderabad. He got his PhD degree in JNU University from Anantapur, and currently he is working as a coordinator in intellectual property IPR cell in the Sri Vidyanikethan Engineering College, and he is guiding 2 PhD students, and he already guided 8 MStech students and 26 BTech students, and he has filed around 13 national and international patents, and he has 2 books and 3 book chapters, and he has attended more than 70 workshops, FDPs, and he acted around 20 workshops like this. On behalf of Adi Shankara Group of Institutions, I am welcoming you, sir. Please, once again, good morning to you, sir. Welcome you, sir, Bashir, sir. Over to you, sir.
Right. Thank you for introduction of my profile. So, Assalamu alaikum wa rahmatullahi wa barakatuh. May the peace and mercy and blessings of Allah be with you. A very good morning to the dignitaries, directors, principals of various institutions of Adi Shankara Group of Institution. And first of all, I thank to the management of AGI to accept, to act as a speaker, to deliver my knowledge, whatever I have on the topic IPR, intellectual property rights. So just I'll right. Hope my screen is visible now.
Yes, sir. Okay,
Yes.
sir.
Yeah.
Go ahead.
Yeah. Fine. Thank you. Let me start the session. This is actually the plan of session is 1 hour 45 minutes, and the last of 10 to 15 minutes will go for queries. And no doubt, you will not be bored in my presentation. Definitely, you will get more knowledge. And first of all, try to listen with a fresh mind, so that from the scratch we are going to be starting of this IPR. The title is very beautiful, quoted from the Adi Shankara College. There's a thanks to the team who have done this. Protect your idea, get patented. So let me start. As we have, after the completion of this program, definitely some of the outcomes can be met. The first outcome can be how IP is relevant to you. The second, in your mind, that which IP can I select? And the third, how to identify the research area or idea. The research area, or can we have the idea further? And not only this, we can also have the is my idea is patentable, and how can I protect my IP? Can I commercialize my IP? So these are the few outcomes when we see in the completion of this session. Now some of the material, some of the images is a common courtesy I'm giving to all the peoples who have given in the open source databases, and I'm giving my heartful courtesy to all the peoples in a common way. Okay. And this is the content today we are going to be talking about. We'll first talks about the intro part of the IPR. Next talks about different IPRs. And most of you are aware that only IPR means only patent. It's not only patent. IPR having the different ways or there. And which one will comes under is a patentable, and which one comes under the non-patentable. And also how to do some open-based database searches. How to do the open-based database searches in the patent search, and what are the sources of that, and we'll see the patent processing as well, and we'll discuss something about the digital signature. If your team is interested, we'll go for a live demo. This is optional. That's depends on your activeness. Now let me go for this. Right. Fine. So let me start with what is a IP. The right of an individual not to have is new product or process of making a product copied by others is known as intellectual property right. In simply, if you say that the original intangible, that is creating from one's mind, is called as an IP. It's not a patent, it's not any copyright, it's not a trademark. Only IP, intellectual property. Intellectual belongs to the own's mind. If it is created with own's mind, that creation is called as a property. That's why it is called as intellectual. Whose intellectual it is? Human being mind. That has created from their mind, and that outcome of that mind of that particular person comes as an outcome of a property. So that simply is called as an intellectual property. If you see at the left hand side, I will show some of the figures which are the different IPs. Now, if you see the Hyderabad Dalim, both are look the same. This is one type of IP. But taking some ingredients of the same will not be prepared as same as the style of Hyderabad Dalim. If you say the Coca-Cola, there is having the different in that there is a shape of color, font, the size tin, the marks, text marks, all that. So in this trademark, there is a different types of IPs are involved. If you see bottom, there is a book, that is a published copyright book. And if you see some Gitanjali songs, such type of another type of IPs. Let me discuss one after the other how many types of IPs we are having. Roughly, we can have the industrial design rights, patents, trademarks, copyrights, geographical indication, trade secrets, the integrated circuit, layout design. Let me see one after the other. Let me start with first is with the copyright. So if you observe, copyright deals with what is a copyright normally. So it is a normal original work that is going to be authorship. So that work can be include like the literacy, or maybe a dramatical things, then maybe musical, artistic works are such as poetry, novels, movies, songs, computer software, everything will comes under copyright. The lifetime of this copyright, if you are dealing with literacy and the dramatical or maybe the musical artist works, it goes to the lifetime period is author's lifetime. Say for example, my age is up to a lifetime in the sense I can live for maybe 80, 85 years plus 60 years, totally 1, 4, 5 years, the authorship can be given. For cinematography, sir films or photographs or anonymous any other works, that will give only 60 years. If you see the broadcast things like the movies, it is purchasing the satellite rights, it goes for 25 years. Now, what is the procedure to apply for that is we have to apply through a separate copyright forum is there, copyright website is there, like the patent for other IPs, there is a copyright, then directly we can apply for that. And we can get the legal rights. Legal rights means the authorship of that is goes to the who have done that. Author can done this. So 60 years of protection will be there. We can do the import and export rights. Import and export rights means we can take, we can sold it. That is called as important export rights. We can assign to third parties our rights. We can generate some economic here, and we can also have some moral values. Moral values is nothing but generating from ones. Only you get the moral values as well as the economical rights also you can get. Moral means only moral values is belongs to a particular person. When you become as a economical, you are transferring that copyrights to other person. But whatever the moral values is with you only. You have sold them to that third party, but only you have gained the economic. Only economically that third party is eligible. But moral values, even though you have sold to the third party, the moral values is yours only. Exclusive rights in the sense we can take some extra permissions, exclusive permissions from the third resources, like from the publishers or from other peoples, we can take that the external permissions as well. Let me see the next part of this is examples of this copyright. Like we have seen when you're installing any software, like we have the copyright Windows 7 installation. When you see some any language of this, there is a copyright here. If you observe sometimes in the YouTube, some copyright claims has because of somebody has make a case on that. Because of that, they remove some content on that. This is the copyright things. And if you see in the book bottom, there is a copyright. If you see the good morning song, birthday songs, all will come under the copyright. Coming to the second one, trademark. Trademarks are three types. One is the unregistered trademark, the unregistered service mark, and registered trademarks. So this three will be talks about. If you are observe here carefully, the TM most of you have seen in most of the trademarks things, that is a unregistered. Now SM unregistered service mark, and or is a registered mark where R stands for. Now what is a trademark? Is a word or a phrase or a symbol or a design or combination of a word or symbol, combination of a word, symbol, design, all will becomes under a trademark. Now we can also have some unconventional trademarks, like for including letters, numerals, words, pictures. Let me see some examples of this trademark. Before that, let me see the protection, like the copyright having the author's time like 60 years for some type of copyrights. For some type of it is a 60, for some time it is a 25. Now this having the 10 years, there all the rest of the things is the same rights as per the copyright. And one more important is a territorial. This territorial will call as, now you have a trademark in India. If you want to be launched that trademark in another countries, again we have to take extra permissions. That is called as territorial rights. So country to country, we have to take the permissions. That type of permissions is called as territorial rights. The other things is as usual the same rights we are having. And the next part of this is next. Let me see some examples over here. This is some most of the examples you have seen in most of the cases, like where we can see just do it, or I am loving it, Apple symbol, lace, the phrase, Intel symbol, Intel where it is a or registered trademark, Hyundai or Coca-Cola, Maggie, at some all such type of Microsoft. If you observe carefully in the Coca-Cola, there is a color, the font style is a combination, a word, phrase, symbol, design, all together. Now here also having some designs, here also a few this. So it includes a trademark means not only includes a color, not only includes a symbol, not only includes a picture or design, it is a combination, sometimes it's a individual. Okay. So that's the examples of trademark. Let me go for the next is trade secret. So trade secret, the meaning itself, secret is, if you see most of the time, this trade secret, we'll see some examples so that you can understand clearly. It's a information owned, developed by a business that gives it a competitive advantage. The meaning here is now nobody, the secret of Coca-Cola, the secret of KFC will not be revealed. So they only have take the trade permissions, but the secret how they are preparing, how they are doing that one, it not be revealed. So for this type of things, there is a merits or no registration cost is required, unlimited protection until unless you reveal that secret, no registration process, immediate effect will be there. Whenever you have gained that secret, from that minute, second onwards, you have the rights. Okay. So problem is multiple means of security we have to protect carefully. If you reveal the formula, then definitely there is no use of that trade secret. And that is a major drawback in this one. And let me have see some examples over here. The examples of trade secret. If you see the Coca-Cola or the examples, preparation of the information is not revealed. The recipe of KFC chicken not revealed. The formula for Coca-Cola product formulation not revealed. The formula for W40 not revealed. The algorithm or the program which they are going to by the Google for the searching, they are not being revealed. So such type of things will be called as this trademark secret. Okay. Fine. Let me see the next part of this geographical indication. So geographical indication, it talks about a sign used on products that is specifically geographical origin. Origin in the sense the location. It's a location based location to location. It will be changed. Let me have, I'll explain with some example. And remember the protection time for this one is 10 years. Let me go for directly with the example so that we can understand clearly instead of the definition. Tirupati Laddu. If you are preparing in Tirupati area, then only the taste of that laddu will be have that much. If you take the same ingredients, whatever the laddu for preparing that laddu, whatever the ingredients are taking, if you take that ingredients and go to Mumbai or Delhi or Hyderabad or somewhere, if you start preparing that same with the ingredients with the same peoples, the taste will not become, because it deals with the atmosphere, it deals with the climate, it deals with the where we have the nature, the air, where the location. So location to location, the taste will be changes. Similarly, Kondavalli Bomalu, similarly Araku Valley, the Arabic coffee, Kolhapuri chapels, the Darjeeling tea, or the Kadamalai Haldi. That it's based on every location to location, it will be vary. And coming to the next very important of this is industrial designs. Under this industrial design, what it deals with is for any features like 2D, 3D type of features, any patterns, any ornaments, if you are going to doing that with the color, shape, then we can apply for this industrial design. So the lifetime period of this one is 10 years up to we can extend another 5 years based on the request from the office. Right. So criteria for registering is we had it is pretty new, original, definitely, not disclosable publicly anywhere at any time, significantly distinguished from the previous design or other designs. It has distinct unique feature, does not contain any scandalous or obvious matter like any regions or any goddess or god's photos over there in the designs. That will not be allowable. Okay. And see some examples. We have different categories in the industrial design. Consumer products like purse, brush, or the iron box, scissor, all like chappal type of this, or comb, clock type of, all comes under consumer products. And let me see the medicine type of, like for sanitizing, there is a bottle of type injections or caps, whatever the caps type of tablets you are going to using, that, and all such type of things will comes under this, the pharmaceutical. And the next is textile and jewelry. So the cotton is common. Based with the help of that cotton, how good you are making the designs of that, the design of, and the jewelry, the gold or maybe diamond or silver. With the help of that, how you are going to preparing some different designs over there. That will comes under textile and jewelry designs. And the next part of this is the layout design of integrated circuits. Integrated circuits mainly deals with the electrical and electronics or mechanical type of peoples. The layout is a design we are going to giving. It's a 3D dimensional disposition. The example I will give you an overview. Say for example, we have Intel laptop, the Apple laptop, or maybe have another Samsung, Lenovo, different laptops are there. If you see from the 3D, from the top view, all the motherboards of all these laptops or all the CPUs of this one will look like same. But where is the design has changed? Where it has changed? The layout. The layout has changed. All are having the RAM, all are having the hard disk inside, all are having the SMPS, all are having the buses, all are having the graphical slots, all are having whatever it is there required for running that, the motherboard, all will be there. But where it is changed, the layout design has to be changed. That is topography, it is changes. The elements, at least one of the active element or some of the interactions of an integrated circuits in the 3D dimensional disposition has to be there. and it not be non-registration layout designs, not original, because the design will look like same, but only some of the elements is moving from this position to that position, that position to this position, has been commercially exploited anywhere in India, or no inherently distinguished, not required to have a from any registered layout design. So that is one advantage of this. Coming to the main important IP, that is patent. Now, patent is a set of exclusive rights granted by a government to an inventor for a limited period of time. And remember, here this patent is giving exclusive right. Exclusive rights means exclusively for you only. Exclusive right. Who will giving? GOI, Government of India, is giving exclusive rights to you for a limited time of period. What is the limit of time period of this patent? Is 20 years. It is having the legal rights, is having the technology monopoly. Now you have in your mind, there is a question that we have seen just now with different types of IPs, like copyright, we have seen trademark, trade secret, we have seen geographical indication, we have seen industrial design. What exactly differ from that IP to the patent is technology, where we are adding, if you are adding technology in the previous IPs, it not be a patent. If you are adding technology, then it is a comes under patent. That is, technology monopoly is one difference, major difference compared with the previous IPs. And there is also be territorial rights, because if you want to take the right in patents in India, it will only applicable for India. If you want to take another countries, you have to take that. And we can make commercialization and we can make exclusive of this right. If you see the figure, it is showing whenever, if you want to disclose to the invention, why GOI is going to be interacting here, why the government of India is going to be interacting, because we are filing if in India, it is GOI will be taken. If you are filing in Australia, if you are filing in the US, if you are filing in Japan, that government patent offices will be involved. Why they are going to be involved? To check whether how much suitable that invention to the public. It not be how make some any uh, uh, or else any effects out there for the peoples who are released to the market. If you release to that one, any side effects are there, any problem will be there, whether it is related to any terrorist type of invention, what type of things, that has to be clearly to shown. This right has to be taken, disclosure of invention. Okay, so inventor to the public, we required some exclusive rights. And here I will show you one example here. Just take 30 seconds of time to you, 30 seconds of time to you, and whatever the just now we have seen the copyright, the patent, the design of this. Now this is a camera, right? Agree? Under this camera, you please identify yourself. No need to tell the answer, but at least think about yourself. Which one part comes under patentable? Which part comes under copyright? Which part comes under the design? Just in the single camera. It is not only one IP here inside this. We are having more than one IP. I'll give just 10-15 seconds of time to think about this IP. Fine, great. So now let me see what actually the things are there. Now, see in this camera, the first one, if you are observed, the Sony, the name is called as branding. It's a registered trademark. Flash, there is a technology. It is a patented. The third, the lens. It is a design and technology. It is a design patent as well as the utility patent over this lens cap. And lens technology, the fourth one. Inside the lens cap is different. Lens inside is different. That is a lens technology, patentable. The fifth one, picture. That is picture captured by camera. It is copyright, because whatever the pictures you are going to be capturing, the camera is different, but the same camera can be captured the different things also. So it is going to be having different copyrights. And design camera, it is a body of this one. It is a patent. Okay. So coming to the comparisons of this, all whatever I have discussed, patent, copyright, trademark. Patent is required. A new and useful invention is required. The lifetime of the patent is, for the utility is 20 years. For design patents is 15 years. How much of time it takes for granting is minimum to, it depends on that, 4 to 5 years. And very important point in the patent is a new useful obviousness. That is non-obviousness, meaning is any at least one inventive step has to be there, then only can we get the grant. The copyright for the original literacy artistic works, it is maybe a lifetime plus 60 years. For a creativity of copyright 60, for broadcasting 25. The time taken for copyright is 2 to 3 months. And originally creativity. And trademarks, it depends on the product. It will be 10 years plus extendable for 5 years. The how much of time to get the trademark is 1 year, and can be marked as a distinct. So this is a comparison between the patent, trademark, and copyright. And coming to the next topic of today's session is patentable versus not patentable. So which one will comes under patentable and which one comes under non-patentable? Let me have a glance over this. So if you observe carefully the patentable invention in the figure, this is totally this circle. This total circle is going to be talking about. This is an all ideas. Among that, this only some part, some zero part of this very small part also will comes under patentable. Okay. Now here the patentable can be very clearly mentioned if any one of this or three steps or combination of these steps, if you are having in your patent, then you can be claimed as a patentable. Now if you have in your patent is any novelty, non-obviousness, meaning is inventive steps is there. The third, industrial applicability is suitable to any industry applications or not. Let me see one small example over here. The invention for a patent. We have a chair of wooden chair consisting of with 4 supporting legs and which is circulated shape, sitting surface mounted on 4 legs. This is the invention. Now among this invention, you have to be checked whether any novelty is there, any inventive step is there, whether it is really useful to the industrial application, industrial in the sense, all industries is useful for that. Maybe in any one of the industries is useful or not. If any one of the answer or combination of the this 1, 2, 3 or combination of this one will be there, then definitely we can claim for a patentable. So patent it can be called as novelty, means it should be a new and not yet public to the to any one of the forum, not in the blogs, not in the forums, not in the anywhere. It has not be published yet. And whether we are adding or improve something that are already existing to the subject existing subject prior art, test for patentable, that is these are the steps are there or not, we have to check it. Non-obviousness means inventive steps, remember the word. And industry applications applicable to the industrial applicable results in revocation of a patent. It had give some sort of outcome over there. Okay. So that's about the patentable. And coming to the non-patentable, very important this, and please make sure that before you are going to be filing a patent, whether any one of this law we are going to talking, if the patent is not a patent, if the patent is not a patent, that is called as non-patentable. That is not a patent. That will comes under, we have different laws in the patent, and under that there is a section 3 which will comes under non-patentable. Under the section 3, let me see which are not a patentable, which are comes under non-patentable. Let's say for example an invention which is a frivolous or which the claims obviously contrary to establish the natural laws. For example, already there is a transportation is there. If you are making a teletransportation, just booking a call and booking for a online shopping products, if you are taking, it's not a patentable. If you are saying that produces 100% efficiency compared with the existing one, it's not a patentable. Any loss there, the contrary of laws or thermodynamics laws are there, already is there, the loss will not come under this type of patentable. Under the section 3B, the contrary to the public order morality. Example, if you are developing a machine which is generating the currency notes, it's not a patentable. An invention of adulteration of the food products, like you are develop a food product which is suitable for 5 years of babies or 10 years of kids, then it's not a patentable. Invention of mass detections, this also will not comes under patentable. Under the section 3, discovery of a scientific principle or abstract, that is Newton's law of gravity, or we can give some freely in the nature, like we'll talk about in the 3D in detail about this 3C, new form of a noun substances. For example, you have used a aspirant for heart elements. If you are only using that one, it's not a patentable. Or with the help of neem, you produce some ointment, or if you produce some type of treatment which cure some other disease, it's not also becomes under patentable, because already neem is a nature, belongs as a nature. If you mix up with the neem some any sort of the other ingredients, and you develop or you have to propose a new treatment or a new product or some new tablet or something, it not be a patentable. Under the section 3E, it is an admixture. Like for example, already 2 + 2 = 4 has proved, already is a proven. Now you are saying that you are trying to prove that 2 + 2 = 5. Now 2 + 2 = 5, it is not a patentable. Example, already paracetamol is there. If you are adding one more antibiotic for that paracetamol tablet and combine that one, it gives some another to effect to another, like when you have the fever of 103, 102, then you can give that tablet, then it is a workable. it's not patentable because you are mixturing already tablet 1, tablet 2 is there. You are mixturing tablet 1, 2 and producing as tablet 3. That will not be workable. But here, try to remember in this one, in this case, 2 plus 2 equal to 4. It is already it is there. But 2 plus 2 equal to, you are trying to prove as 5. Whatever the outcome is coming from 2 plus 2, for 5 you can go for patentable. But you can't go for the process, whatever already they have done 2 plus 2 for the left hand side, you'll not go for a patentable. But for the right hand side, the outcome of that, it go for patentable. And 3F action, arrangement, rearrangement. Like already umbrella is there, fan is there. If you say umbrella is there, automatically you can fit a fan inside the umbrella and it is a patentable. No. Arranging, rearranging, duplication will not be workable. The clock and radio will be there. Clock will be on your table. Clock will be on the wall. Radio will be on your table. If you interchange that, it's not a patentable. And if you see here 3H, 3G is going to be amended. If you observe, either after the 3F, there is no 3G because 3G is amended. Now 3H is talking about the agriculture and horticulture. Agriculture, horticulture means just now we have discussed that any new plant you produce by adding some seeds over there, or from goat, any other new animal has came outside from the delivery. It's such type of things will not be patentable. Mathematical or business model or computer program. Most of we are in this era that we are developing a program, we are developing a mathematical addition, we are developing an algorithm, we have enhancing some delta exchanges. Such type of things will not be patentable. All the programs, if somebody develop the program in Java, somebody develop the same program in Python, will not be patentable because only you have changed the programming languages. There is no process, there is no product over there, then that type of things will not be patentable. Under the 3J, plants and animals. Plants and animals is nothing but like producing for a mango tree, any type of Goa, from producing from a Goa tree a mango. Such type of things will not be patentable. And process of medicine and curative or treatment of human being. Some already from our grandpa to grandpa, they are following some which is following some Vedas or which is following from Qurans or following from Bibles. Some type of treatment will be there. Such type of allopathy or such type of things you are adding and cure some type of diseases, such a big diseases like cancer, such type of that type of knowledge. If you are applying for patent, it will not be patentable. Okay. And 3L already you know the copyrights. It's the literacy, dramatical, musical, artistic work. 3M is a performing the mental act, means like your cross puzzle is there. Somebody in a shortcut solve it. Somebody solve in another way. Like it is not workable. Somebody write the code in 3 lines. Somebody write in the 2 lines only. It is not a patentable. Somebody are playing chess in a faster way. The method of teaching. Somebody are using PPT. Somebody are using different methodologies. Somebody are using the classroom teaching is in a different way. There can be go for a flip-clad classroom, or they can go for blinded learning teaching. If you are changing the methodology, it not be patentable. Okay, so under the 3N, like presentation, somebody have prepared some presentation. If you added the voice background, it will not be patentable. Somebody has to prepare a voice. If you convert into text, it's not a patentable. Somebody have to be spoken in the words, like in the pronunciation, in the slang. If you're changing, it's not be patentable. And some integrated circuit, just now I have said you, all the circuits, integrated circuits, layouts will not be patentable. That additional knowledge, just now I have said it. And under the section 4, invention related to atomic energy, not patentable because atomic energy is will take care by the GOI. Okay, so these are some of the ways where we can't be patentable. Coming to the importance of patent search, this is very important. Most of us, we are going to be instructing to the students, maybe for PG students, EG students, or PhD students, that go for these papers, take the IEEE paper, ACM paper, elsewhere paper, something. So how many of us we are going to be recommending to search the patents? Because patent 70 to 90% of the information contained within the patents is never published anywhere else. That is a unique content will be there. So that's why I request you, not only the journals, conferences, some other sources, but also give some stress on the, when you are searching any for work or for any journals, any conferences, look also in the patent search as well. Read patents, not just papers. Okay, if you know your enemy and yourself in 100 battles, you will never be defeated. Now, what are the importance of the patent searches? It's freely available. Anybody can give the access of this. Anybody can access this. Detailed information is there because all what is the invention, how they done it, the methodology, everything they have kept it in the documentation freely available. Both national and international also it is available. So it is a market related, application oriented, industrial application related ideas will be there. And these researchers or maybe the product developers, inventors, or the tentative applicants, the patentees, all can be used this type of patent search. That are the benefits of this one. And coming to the how to conduct the patent search, the next topic, how to conduct the patent search over this. And I'll show you some of the patents before going to be open source databases. Before going to know that it is an art. Searching is nothing but only just not sitting on the in front of system and open a browser and type some keywords and you are getting downloaded without any preparation, without having any background or any background work over there on a paper. You don't sit in the front of system and just start typing of this. Somebody say that take the prior art or literature survey. They open the system, open the browser, and that start typing it. But what you're typing? Do you have any idea before that you can start the searching of anything? No, because we have to make some working on that, make some background work on the paper, then you can start working. Now let me see how to conduct the patent search. Before going to that one, let me see some challenges over here. Okay, the challenges are the drafting language. Now, normally if you know the abstract of a journal or conference, it looks like what? The first sentence of an abstract of a journal or conference. The first sentence is a topic. Next is the topic issues, how that issue has solved. The next sentence. The next sentence talk about what are the limitations of that existing technology or existing techniques. The next sentence talks about how you are overcoming in this proposed one. The next topic talks about how you are going to, what is the process, how you are doing. Next is where you are applying for that, which application, which real-time embedded system, or which real-time applications you are going to apply. Next sentence is what is the results you are getting. Next sentence talks about what is the feature. This is some 10 to 12 sentences where an abstract of an conference or journal, mainly it is a most related to the journal, it is look like. But the abstract of patent is not like that. The abstract is going to talking about with respect to your drawings, with respect to your design of your patent, with respect to design of drawings of your patent or invention, where it deals with that. So the challenge of reading the abstract here is definitely we have to be make sure this 1, 2, 3, 4 is a not the sentence numbers. These are the drawings. In that we are going to have splitting the drawings in the pieces. Each piece we are going to represent it with the number. That number you are going to mention. A card connector includes an insulating house. One in the sense how that card connector includes insulating housing. If you go to the one in the drawing, in the one of the drawing one, that one indicates the card connector includes the insulating housing, like it is showing there. Like similarly 2, 3, 130. It's numbering is your interest. You can use 1000, 1002, 1003. Somebody can use 1, 2, 3, 4. Somebody can use 101, 102. Somebody using 201, 203, maybe 1300, 1400, like this. You can use the numbers. There's a first challenge, drafting language is very important. The second challenge is like when you are doing the any invention in the chemical type of things, while you're searching, normally the text will come. But this type of patterns, the chemical search patterns will not become that much of easy. We had to be gone through the pattern. Again, we had to study that one, how they are designed. Based on that only we can come to conclude that whether my invention already there or not. So chemical search is another challenge in the patent. The third challenge is patent language. Somebody, you already have the idea, but somebody you're thinking that Japan people has done that invention. Now in the India there is no, so I can convert into Indian thing and I can go for patent. No, whatever in that in anywhere in the world, the idea is there. The idea is there. That's all. That not belongs to any country. If you want to be climb, then we have to go for country to country variation. So converting from one language to another language. If you don't know the Japanese language or Chinese language or any other sort of these slangs languages, we have to convert that one and we have to try to understand that one. Very generically, they don't write the abstract specifically. They will write generically. If you go through the document only, we can get the things. So converting one language to another language, that is patent language, is also a very important challenge. And typo errors. Somebody are typing just simply embedded, means they are missing EMBEDED. Somebody are typing as EMBEDDED. One more D as extra added. So adding of single character extra also it gives a wrong results. Like Hyundai motor, Hyundai of this, Hyundai, all this type of things will give different searches will be there. Okay, typo errors also be a big challenge in the patent search. And keep it in this all in mind. Let me see this figure. Now we have in your question that what is the difference between prior art and prior use? Art is nothing but here talking about the existing and the knowledge whatever you are going to using. The knowledge what you are going to using, that existing knowledge is called as art. Now use means whether that knowledge is applied in somewhere, applied to the real-time industry or not. Applying that use, that is comes under prior use. Use means applying that knowledge. Art means knowledge, existing knowledge or new knowledge applying somewhere is called as prior use. If you see this figure totally, it is a 10 years of the survey, how it will be. The prior art, the circles, which is having the different colors, Indicates, each circle indicates what is the source. What is the source you are going to be done in the 2010? How many number of books you have referred? How many number of journals you have referred? How many number of the patents you have referred? Conference proceedings, product brochures, the academics publications, the blogs, the videos, or any other material. How many you are such that will be talk about? This each color indicates. Not when you are making any invention, don't be fixed for only journals. Don't be fixed for only conferences. Don't be fixed for only patent search. You have to be searched from all the corners, from 360 degrees, all the corners. You have to be searched and define that in anywhere, in any line, in any forum, in any WhatsApp, in any Facebook, in any Twitter, any LinkedIn, nowhere this type of the invention, the line is there. Then only have to come and conclude that this invention will be a unique one. So this is how we can do the prior art or prior use of this. And coming to the process, how to make a search of this one. First of all, we have to make sure what is the concept. You have to be identification. Now you have to put this on the paper. On the paper, you have to do this workout. Concept identification, like first of all, you have to identify the key concept. What are the inheritance or hidden concept inside that, and what are the variable features. Let me see one example with this so that we can understand clearly. Next step, you have make sure the keywords or classification codes. Keyword search is normally if you want a PDF files on any cloud computing, PDF files on cloud computing. This is a keyword search. But classification code in the sense for every area in the patent, in the ICT and in the PCT of the Patent Corporation Treaty and the ICT International Corporation, this patent will have for each area in the embedded system, for IoT, for cloud computing, for mechanical, for chemical, for physics, for in all the areas, there is some classification codes. If you add that classification code to your search, it gives you an optimized and very precision type of search. It will give some very close relevant. The precision and recall will be give very closer to that relevant search over there, right? So this query formation search, once you have done it, you can make a query formation. And we have just typing as only we are using which type of operator in the normal typing of query, space, PDF space, files space, on space, cloud computing space, like you're using. Not only that, we has to use some other operations like truncation, Boolean operators, proximity, parentheses, searching strings, selection of database, some other things also we need to use. And additional searches, like we need to add the additional keywords, additional codes, the citation search, or inventory assignee names or similarity searches, all such type of you are added, then it will give very closer information. So remember, when you want to be search a patent, you have to make conceptual identification first out. Next, we have to make out what are the keywords, classification codes for that search, the queries, what we can use, and additional searches can be doing. Let me see one small example over here. The word truncation in the query search formation. Word truncation means you can use star, question mark, dollar, plus symbols. Star indicates like technology. Example, is it technology or technologies or technological? All keywords will be comes. After the G, if you are going to be using a star over here, if you are using a star over here, it will come all the three. Patent, patents, patentable, patentability. Like if you are going to using a question mark, 1 or 2 characters. The question mark is 0 or 1 character. Like we can use the plus symbol, we can use the dollar symbol in front of that. And we can also have the Boolean operators like and, or, and not. And means the union of this, or it is going to be done in the both. In the both, and means it is going to be have intersection, and or means is a union, and not is opposite of that. Proximity operators like adjacent, near, same. What is called adjacent means adjacent W to W. Say for example, flame to W. This is the example. 2W resistant means after the flame word, the 2W means the 2 adjacent of that. Towards that 2 characters after the flame, search towards to the right. Any word that is resistant is there or not. In middle, any 2 words are there. So such type of searching is called as adjacent. Coming to the near to the 3D. 3D is nothing but it will search from D in the sense right side as well as the left side. Both the sides it is going to be search. Same is nothing but exact. And not only that, we can use the parentheses, we can use the square brackets for better combining multiple queries in that search. We can do it. Such type of searches, if you have done, definitely it will be very useful. Related information we'll get it. But mostly we require patience. Without patience, we can't do such type of thing. Say for example here, the keyword search can be done like concepts. We can use the power, toothbrush, the position, monitoring, sensors. We are going to using this one. Power may be a power, electrical power or electronic power. Some other related narrowing search down to that one. such strings we can use like plus or and like this we have to be planned. So this type of working has to done on the paper before you're going to sit on the system. And patentable classification code, as I said, you for shirts or for IoT, for cloud, everything in the form of a, this is the codes. Now let me see what exactly that code indicates. If you see, if you're searching for any one automation word, example, which automation, where in the engineering, in the civil engineering, in the building construction, in the automation, we are going to be searching. That is a narrowly had to be make sure that what type of automation you require, in which type of automation. And the searches, if you are going to using with the help of the classification code or with the help of direct search, keyword search, with the help of very different synonyms, giving some different keywords. If you are search in the different languages, if you are search, you will get the search like this. The circles, pink color indicates if you search with the keywords. The light green, it indicates changing with the different synonyms. Alternative representative languages, if you change the languages in the searching, we'll get it. This color, the last color indicates the classification code, indicates if you are adding the searches, how it is closer. See the circles here, we are going to be mapping the circles over here. This circle and this circle and this circle and this circle. So closer, if you are observed closely, when you are adding with the classification code to your keyword search code, then more relevant information will get you. That's the meaning of this slide it is going to be talking. So if you are closely observe of this one, the search contains this 40% of this color, 60% and 70%, 100% if you want, you can use the classification code as well as the keyword search code over there. Then only you can get it closer information. If you can't get the closer information, you are not able to conclude that this is my invention, right? Like we have needed some the full forms, like IPC stands for International Patent Classification Code, CPC stands for Cooperative Patent Classification, and most of time it is going to be using in the upcoming slides CPC, IPC regularly. You please try to remember this. Next, we'll talk about a small example over here. Now, just a point here. These are the different classification international codes. For Japanese, there is having Japanese classification system. For Darwin classification system, they have their own manual codes. For the Lacnono classification, there is own. For our India, there is a WIPO. This also international, and this also include all. So you can make sure you remember the patent classification system is WIPO. If you not remember other, it's not a problem. But try to remember the WIPO, WIPO. This is the International Patent Classification Code. What is the need of this classification code means to know my area is, for example, cloud computing security, or my area belongs to electronics. In the electronics, I'm going to be planning for a device belongs to the visually impaired people. So that device which belongs to the electronic. Now we need to be such what the classification codes means. What are the till now the devices related to the visually impaired people or related to the electronics belongs to solve a particular problem. All such type of devices will be available in that specification with the specification code. All such type of device will be combined, integrated into that one. Let me see the example of the classification. So for example, if you have a classification code like this, A46B 13 by C, A is indicates section and the 46 indicates is a class, B indicates is a subclass, 13 is going to be using a main group, and 00 or 02 indicates subgroup. Meaning of this one is example, brushes with driven brush the bodies. The brushes is there with the driven means automatic brushes. If you want, you can use this classification A46B 1300. If it is the classification, the subgroups after the 13/00, if more the subgroups are there, 01, 02, 03, 04, more the number of subgroups are there, you think that more invention, more research work has done inside that category. So if you see 02 means it is a brushes with the power. There is only driven, there will be a power. Again, they added one more invention for that, a power. Like this, if the more the value after the slash 02, 03, 04, 05, 06, the highest value indicates more the research has done in that particular area. Okay, so try to remember that the classification. And the simple test step process for searching is identify all the concepts in the invention first of all. Next is identify the all synonyms what we are having and see the word truncation and go for the form search string and the search formula and narrow the classification code. Now let me go with an example. Now see here, she's cooking and is going to mapping. She's cooking in a nice meal. I am watching television. Mala is standing under the tree. Renu is washing dirty clothes. and Harshita is driving very fast. This is not one-to-one mapping in the patent. One thing can be mapped to many, like she's cooking under the tree, she's cooking very fast, she's cooking a nice meal. You can have multiple different combinations also be available, right? So where I can be search, where I can search this one. Before going to be coming to that one, let me have a example how to search any idea or any one invention, whether it is there or not. You please make sure. An example: child safety seat belt in vehicles. This is the example we are going to consider. Now, whatever the 6 steps we have discussed for searching a patent, first of all, we have to identify all the concepts in the invention. All the concepts in the sense in the child seat belt vehicles. These are the concept in this line of my invention. To search whether it is there, whether any similar works are there, to search in the patent open database searches or paid database searches, child safety seat belt in vehicles. This is my line of example. Now, what I'm doing here is the concept I need to identify. What are the concept I'm identifying? Child seat belt vehicle. Now, identify the synonyms for each concept. Child can be also called as kid, infant, child, children, etc. Child, C small or capital. Seat belt we can also call belt, fastener. Vehicle we can call as vehicle, car, bus, van, automobile. Multiple words, multiple synonyms will be there for each word, right? Now, apply the truncation. Like truncation means we can apply the star, question mark, dollar, plus these are the truncations will be there. Apply some search strings. We can apply the parentheses. We can apply some Boolean operators over there to make the search very convenient and relevant search. Apply the proximity operators. Search the with the help of some the combinations, like with the proximity operators also you can use over here, and narrow what with the classification code for seats child belts. This area belongs to the safety. The area belongs to safety, which under that again for safety, adult or child or visually impaired people or maybe have low vision people for whom we are going to providing safety, that will be decided in the classification code. See, B60R is belongs to the automobile or safety. Now under that there is a B60N2/26. This is another classification code which is related to that. If you combine, if you search in the last 6th step, if you search like this in the open databases or paid databases, patent search, definitely you will get very relevant, very close related to the invention or the title what we want to search, that child safety seat belt in vehicles. That is how you need to prepare the query, not simply just typing of this statement in that databases and typing of this statement will give more accurate result and more relevant result compared with this. If you give this is here, if it is give 1 lakh of searches it is giving, maybe after applying this one, it will give maybe it is a 1K, that is 1000 searches only that will give you. That much of VT we can have in this one. Okay, now this is how the example we'll talk about. Now let me go for this is how we can be divide the concept. Now go for the databases. Now as I said you that what are the different open databases we have. Let me talk about that one. We have the open databases such as worldwide eSpaceNet. This is the page how it looks like, where you can go for search for classification code. If you don't know where I need to search it, go to the website worldwide.espacenet.com, and once you go for there is the different classification codes will be there. Let me have a look if it is get the faster internet. So this is the eSpace internet. Now here there is a classification search. See here there is a classification search A, B, C, D like this. Okay, these are the things you can make sure which area. Like for example, your area belongs to starts with chemistry. Under the chemistry, these are the different C02, C01, C02. If you want under that C01, again there is a different classification codes are there available. So which area? Again C01F. Again there is anything you can search and you can find out your classification codes. Okay, so like this also we can done your searches. And also we have another open databases like we have like this, the Google Patent we have, and we have the WIPO, that is patent scope WIPO.in, the search of this. And we have, like just now I said, eSpaceNet, and we have INPASS. This is the Indian Patent Office, INPASS, ipindiaservices.gov.in. We can also use the USP2, that is United States Patent and the Trademarks Office. We can also search in this one. So these are some of the open databases we are having available over this. And also not only open databases, we have the paid databases such as the Clarivate, very costly database. To like when you want to apply the plagiarism check for your paper, if you search in the open databases, it gives normal similarity level is very less. If you search in the same in the paid plagiarism tools like Turnitin, it give accurate result exactly, because the Turnitin will have link mapped with the different databases. It's search in the different databases, whereas the open source, the free plagiarism tools will search only open access databases only, not search in the other databases. So that's why the results also will vary. So paid databases like Base, and also we have Crystal, Relicura, and Innograph. So each one having their own different cost variations will be there. Among them, the toppest is Clarivate Analytics. Okay, and with the help of that, we can go for this searching. Okay, and this is how the in-pass will look like the website. And the main the part till now, we are coming to the next topic, that is patent concepts. So if you are observe carefully the patent concept, before going to that one, we'll move directly to the way, say for example, the another concepts are there, very important concept before going to be start the actual live things to show. See the patent concept, other concept other than this, whatever you have just now discussed, other than that, we have still more some other concepts are there, like patentable concepts, the landscape concept, invalid concept, freedom to practice concept. And please try to understand in a single line. I will be simplified this concept. It is very, very important topics in the, because of that, not having the knowledge, simply we are going for patenting the things. So landscape concepts, invalidation concept, free to operate. Now see, free to practice of this. Let me go for landscape. So before going to that one, first of all, decide yourself what is the key strategy you are going to apply. Whether you are planning to innovate, or planning to have a business expansion, planning to have business strategy, problem solutions, or initiate to the research, better the solution for these questions is go for state of search and go for IP land studies. We'll see what is IP land studies. If you have thought of the having inventory or something, also you can go for both of this. You can have a thought of having the invented something, you can go for patentable search. If you want to planning a product to launch, then you can go for free to operate search, that is FTO. You are accused a patent in infringement. Infringement means somebody, whatever you have the idea that somebody has to be making theft of that, or somebody has got using that one. If you want to be accused of that patent infringement and plan to license a patent or involved in a litigation concern IP, you can go for the concept called as invalidation or validation search. Now let me see in a briefly, because it's a big topics actually. I'm just giving in a rough manner to understand very clearly. Coming to the landscape analysis, as I said, tell you that landscape analysis, how we can be do is better. I will show some graphical representation to understand clearly what actually this landscape. See, this is a landscape analysis. See, I'm taking in the y-axis some advantages or properties. In x-axis, I'm taking applications. Now, this two versus of that, I'm taking some advantages of this. These are the list of advantages I'm going to take. And the different applications like the thermal or electronic productivity has applied in which applications, like motor vehicles, automobiles, the aircrafts, or hybrid electrical. These are the different applications, and these are the topics. Each topic where it is going to be applying, like company 1, company 2, or in the source 1, source 2, source 3, different sources, they are going to be using this topic in different application. Make this study very clearly. This type of study is called as landscape, mentioning each subtopic in your main topic, each subtopic where in the real time applications, where it has to be applied, and who has applied, and how much it is going to apply. After doing this landscape analysis, previously also we have seen the prior art and prior use. Prior art plus prior use plus landscape analysis, if you've done, definitely the outcome of that one will be come to a conclusion that where is the gaps are there. See, for example, there is no patents in the line of the with respect to the anti-coercions and with respect to this anti-coercion over this, and in the applications of domestic building industrial application, there is no patent. In the marine vehicles or electrical vehicles, there is no lightweight things out there, and there is no patents at the part of the electrical thermal resistance and in the applications of railway vehicles. So if you identify the gaps, all this no patents, if you identify there, pick many which are very close interested to you, pick one that and start working on this. Unless if you're not doing this type of things and blind, simply you are going to be doing already which is there, definitely at the time of examination, it will be rejected. So there is a waste of efforts, waste of money, waste of everything is waste, right? So that is called as landscape analysis. The second is free to operate. Very important. free to operate it, when we call this ability to make use of or sell others commercialize, otherwise commercialize, exploit a development without risk of being used for infringing someone else's patent. When you want to be sold out, when you want to make marketing your patent idea, when you want to make commercialize, definitely we have to go for FTO, free to operate. Now, what is called this free to operate means? Free to operate is nothing but, I will show an example here so that you can understand clearly. Say inventor A, inventor B, both are there. Inventor A is going to be patent a device having a trigger or spray bottle. This is already there. Having a spray, that is spraying of that, and also a trigger. Now, inventor B has added for this one a controller. They added a controller. Now, inventor B want to be make as a commercialize, make as a market for that idea, make that patentable. Now, before for filing the patent, no issue. But when you want to commercialize, when you want to make as a commercialize, gain some profit from that, definitely you have to check the FTO. See such a way that only controller is the inventive step of inventor B. The other spare and the trigger is belongs to inventor A. So we have to take the inventor B has to take no FTO. If it is given the then only it is go for patentable. Patentable. When you can call as patentable means when it comes as a grant and commercialize, it's a patentable. It's a granted and ready for commercialize. If you don't take the permissions from the inventor A by the inventor B, making some understanding between the two parties or making some any sign-ups or signings, that then only can make as commercialized. Other than we have to wait the permission from inventor A. There is a more chances if you not take the FTO by inventor B from the inventor A can make a case on them or file, go for legally. Okay, so that's the part where we can talk about the FTO. Okay, let me see the next is very important, invalid or the searching. Now, whenever you find out that somebody has to be done existing idea or somebody has to be theft your idea or something, you have to prove invalid search with the help of valid search. So searches are conducted to either validate the claims made by a patent or invalid one or more claims of a computation patent. Here we are doing to justify whenever we have to defend our patent to the patent office with the help of valid searches. If you want to prove, you can go for valid search. If you want to prove that is already my work is there, somebody has to copy it, somebody has to take in that one. To prove that, you can go for invalid search. To prove your claims, you can go for valid search. To prove that somebody has to be done the existing work, somebody has to be do my same work by copied or have taken my rights, means you can go for invalid search. So this can be done. This can be done with different ways. Now let me see one example so that you can understand very clearly. So this can be done. How you can be proved? You can prove the date of filing. Whoever have filed first, they will be claimed. Or else with the help of the background work, whether they have cited or not, or with the help of the detailed description, whatever they're given in the patent documentation, or with the help of the claims, with the help of the invention summary, you can make sure it will be there or not. With the help of all this, we can make or file. We can make file our the invalid concept or conceptual things, and see such a way that subject to claim, not an invention, already there, lacking of novelty, or does not have any involved inventive steps or not useful. Based on this some steps, you can prove that it is a invalid. Okay, I will just explain one example so that we can clearly understood what actually it is going. Say this is the mobiles designs, where what actually the case here is. The case here is the Apple claimed that Samsung has copied the design of iPod of its Galaxy Tab. What Apple is going saying, Apple is claiming that Samsung has copied the iPod design and applied to the Galaxy Tab. For its Galaxy Tab, they copied the design and they released to their tabs. That is a case. So what Samsung has defining, what Samsung company has making invalid of that is, in defense of Samsung, refer to 2001 The Space Odyssey is one of the scientific fiction film released in the year 1968. In that movie, the hero of this person has viewing this a view, that view as same as the Apple design. So based on that, the Apple not be claimed that one. So they have put a case Apple on Samsung. On reverse of this, Samsung has proved that this is a already existing design. Like this, there the case is going on, right? So like this, the things will be there in the invalid concept. So this is a difference between the total the patentable FTO invalid concept. For patentable, remember, for the patentable, you have to make sure the product or process development, the defined invention, it has to be multiple sources. You have to check it out. The year restriction is depends on that 20 years you can extendable. The globally you have to propose this one. We have to search in the non-patentable search also. Whereas others, when you want to go for, when we can go for FTO, we can go for commercialize. When you go for validity, when it is a infringement problem is there. Okay, like this we had to do the comparisons over there. So when go for patentable, when go for FTO, when go for validity. Okay, now to come, this is the basic from the last 55 minutes. I have spoken you, given you clear picture what actually a patent, what actually a patent, not a patent, and how we can do the searches, how we can be done the things, what happening if you're not correctly doing. Next, let's go very important topic, patent, writing the patent. Writing the patent consisting of a different way of procedures. Now let me have talk about the procedures. Now here the procedures talks about, this is the exact the procedure. First of all, we had to file an application. This filing of application can be done in two ways. One is provisional and complete specification. Provisional is nothing but like you have an idea, just write the idea and draw a figure for that idea, just file it. That is called as provisional. Now you have heard about the provisional certificates, right? PC is valid for maximum 6 to 1 year, right? So that is the same case here also. You have idea, there is no thing that I don't have any prior art now, don't have any claims, don't have any proper abstract, don't have any description, nothing as there, only I have idea and have make a drawing. This is what I am thinking. Just file it immediately. That type of file is called as provisional specification. After that, the patent office will give you 12 months of time to you to apply for complete specification. Within 12 months, if you apply with full details on or before 12 months with the full details of your provisional specification, then it is called as complete specification. Now, after the 18 months of your complete specification, after applying that one, it will go for publication stage. Now, once it is published, why the patent office is publishing? It is not like the journals publication or conferences proceeding publication. Why the patent office is going to publish means it is open to all. See, this inventor has claiming that this is his invention. These are his claims, his or her claims. These are his drawings. Now, if you have anybody have any objections, if anybody has any objection, then please come back to our notice. For that, they are going to be publishing to open to all. That is called as publication after the 18 months. Now, within the 3 months of the publication, if anything is there, any pre-grant opposition is there, they will take and again go for call to reapply. If there is no things, they will go for apply for examination. Automatically, once it is published, it goes for examination. But within the 48 months from the filing, the examination process will be done and we will get a FER, where FER stands for first examination report. The first examination report, it is called as FER, going to be called as the first examination report. The FER going to be stands for first examination report. Now, once you get the first examination report over here, the first examination report will come. Now, like this is a report, like how you're getting when you're applying for a journal, they are having 3 reviewers, right? Reviewer 1, 2, 3, or it depends on the journal. They will give some comments. That comments may be some reviewers or reject your paper. Some reviewers give some, the methodology is not good, something is not cited, some already it is existing. It is how it is different to this work to this work. How already this is there. Results are not good. Results are not appropriate. Like minor changes or major changes rejected. Like this, they are giving. In the same fashion, in FER, for every patent, once it is come to the examination, once it is published, an examiner will allocate it. One examiner will allocate it for that patent. The examiner duty is, if anything is came once it is published in the market, any maybe have any issues will come. Anybody has to pose any oppositions has filed that already is there. Any queries has come from the third parties or query from the public, anything out there. Parallelly, the examiner will do is her own style, searching in the different databases, paid databases, searching in the forums, searching in the blogs. They will search in the different ways in their own style. And whatever they have the queries, whatever they have get the issues, whatever they find out the matching to the previous existing invention, all the recordings will be done in this FER. So that first examination report will be released and released to the inventor. They will give 6 months of time to respond to that one. if you are, for the reviewer has given the, like for the journal, if you are giving modify your paper and send it, if they can accept or not be accepted, it depends, right? So here also within the 6 months, you have to respond to for that FER. If they satisfy by the examiner, they'll be granted. If they're not satisfy, as a last chance after releasing the FER, as a last chance, they will go for hearing. They will call for hearing, means a virtual conference. They will be called back, because whatever the queries they have questioned you, maybe you are not properly have given the in the documentation in the draft. Maybe they want to listen from you. Maybe if you are justified through orally, you are trying to explain clearly, they'll call for a virtual conference. In that virtual conference, the inventors can be justify what is the question. This is a question. This is a question raised. What is your answer? What's your justification? If it defines properly with some sort of evidences, defend properly, then definitely there is a more chances for get of grant. Once it is grant of this one, again within the 12 months, if anybody have any objections on that grant, they will again apply for post grant opposition. If within 1 year, if you get any post grant objection, based on the decision of the controller, there may be a revoked or there may be a amendment. If there is no having any oppositions have came within the 1 year after the grant, you are granted sanction. Okay, so that's how it is going to be done clearly. How it is going to be do it. Okay, now this is the normal process. Now I will tell you one more style of process over here. The another style of process here is, here instead of waiting for 18 months after filing the complete specification, directly you can go for early publication. If you wait for 18 months, there is no fee of this one. If you go for early publication, we have to pay fee within the maximum 1 month or 2 weeks, or it is really published. Once it is published, you can go for examination. But there is another option called as early examination. You are not wait up to the more or less 48 months. At minimum 1 year, maximum 5 years it takes to get the FER. If you're not wait up to that one, if you want to go for early examination, the cost also vary here. Within the 30 to 45 days, you'll get the FER. First examination will be get back to you. So that first examination report within 40 to 45 days, 30 to 45 days, will become instead of 1 year to 4 years if you want to wait for that. So early examination, who can be applied? Early examination means when your inventor, any one of the women is there in your inventor, or whether that any one of the inventor is belongs to any small entity, means any startups, or any one of the inventor has already this application has already applied for PCT, that is international patent, has applied for that on patent. In any one of these cases is there, then you can go for early examination. Early examination, not just like that we can go it. We have some constraint for applying for that. Okay, so with the help of this, let me see the different forms. Like we have form 1 to form 30. Form 30 different forms are there. Form 1, form 2, form 3, form 4, up to 30 forms, and also 18A and 7A. Each form having their own the functionalities. Form 1 is when we are applying for an application, online or offline, we have to select form 1. Where in the form 1 we are having the title, inventors, applicants, all the things are available. And provisional complete specifications also the form 2. The complete specification, where we are having the title, invention details, the applicant details, the prior art, summary, description of your drawings, the drawings, figures, abstract, claims, everything will be available in complete specification. And there is a form 3 called as undertaking from the inventors, and form 4 for extension, form 5 for declaration from the inventorship. Like every form having their own functionalities. And form 18 for early examination, if you want to apply for early publication. And early publication can use request for publication is form 9, early examination form 18. Like this, for every one form there is having own functionalities. And form 26 for if you are applying on behalf of you are applying from the through third parties, then you can go for form 16. Like this, every form having their own functionalities and done. And each form, what is the cost of that? When you are applying in the online e-filing, we require there is a cost of 1600 rupees. When you go for physical, it is 150 rupees extra, that is 1750. For form 2, there is no cost up to the 30 pages. There is no cost for the form 2 up to 10 claims. If it is the documentation of form 2, it is exceeded 30 pages, then there is a cost. If it is exceeded 10 claims, there is a cost. Additionally, for each page, for each claim, there is a cost. If it is online, 160 rupees. If it is offline, it is a 450 rupees. For form 3, there is no cost. For form 5, there is no cost. For form 9, for early publication, if you are applying through online, it is a 2,500. When you are applying for offline, 2,750. For form 18, early for applying for examination. For online and offline, both are having 14,000. For applying early examination, form 14A, extra 4,000 has to pay. For offline, it is not allowable for early examination. Like forms 26, like authorship for any patent agent or for any attorney, there is no fee for that. So these are the different costs. Main forms I'm going to showing over here, main cost over there. Now, if you try to remember, if you want to file with on your own through online, 1600 plus 2500 if you are going for early publication, and 4000 for examination. Totally say 8100. That is the cost of for filing going for early publication, applying for examination. This is the cost, 8100 rupees. If you go for early publication, if you are wait for 18 months, this also be reduced within the 5000. This is just 5600. It will be done the job. Okay. And these are the different costs. And we have different offices of the patent, like in Mumbai, Delhi, Chennai, Kolkata. Wherever from whichever location you are applying, that nearby office automatically taken by the patent office. Okay. And next we have, like as I said, you different patent applications are available here. Once you are filed in INPAS, if you are applying for Indian patent in INPAS, these are the different documents it is available. Now it will be available with an application number. It will be like this, the application number, and these are the different forms. Whatever the forms you have applied through online, all the forms are available, open access to everybody once it is published, right? So within the 2 weeks after applying, it will come into your INPAS website. That is the patent office, Indian Patent Office database, right? And let me see some of the inventive ideas what we have till now filed, and roughly I will be just go through that one roughly. And you have a doubt that which one can becomes patentable, which one will not be patentable. Let me have a fast glance some inventive steps over here. See, there is some ideas like blind see and an assistive system for visually impaired people, an agree electronic device for automatic monitoring agriculture, contact selfie ticket payment system for railway gate system early detection and movement, or maybe automatic detection, multi-purpose share, or maybe health care system for remoting to know the behavior of alcoholic person, or to make sure find outing that. And also not only this, and another type of like with the help of internet IoT based, we can have a smart camera where we can monitor the student employee attendance through the any other approaches like deep learning, have a wearable protective device like a mask, making of that with the help of IoT, auto powered assistive device for visually impaired people, like they have the stick, right, for making, if you're applying any IoT for that one, when they're traveling, the battery is the major problem. So how automated power with there, so they are applying some force on that stick, we can add some type of crystals over there in the bottom. With the help of the force applying that one, you can generate some power over there. Such type of can we go for patentable. A smart travel assistant for guiding visually impaired people. These are some of the inventive ideas where these all are patentable. Now let me see one after the other in a faster way. See, this is visually impaired people, how we can be monitored here. But see the process where the GPS is existing, GPU is existing, the cloud is existing, the person is existing, the mobile is existing. But how the process you are going to be. When we can go for patentable means when there is a process or there is a product. In these two cases, we can go for a patent. Now, the process with the help of all these existing resources, if we have a good process over there, then we can go for a patentable. Okay. In similar fashion, if you have another way of is agriculture of this. Now drones is available, sensors are available, mobile is available, all the things are available. Now how the process is any inventive, any non-obviousness is there, inventive step is there or not. If it is there, you can go for a patentable over this. And next of this, here we are going to making sure the process how it is going to be doing over this. Just I'm showing the figure. It is not a time to explain each and every inventive step because we have very less time. Again, the contactless selfie ticket system. Like as I said, this is the entire process. It is available. In this process, all these 11 steps I am having. All the 11 steps are not inventive steps. Among that, any 1 or 2 inventive steps are there. With the help of that inventive steps, I'm going to be going for a patentable. Looking of entirely how the picture will look like, how the drawings will look like over this. Next is IoT railway gate detection, early detection of the movement of this one, early detection of this also, you can go for a patentable. Like all sensors are available, all the clouds are available, or other things are there. But remember the process. The process is unique, then you can go for a patentable. Okay. Next, we can go for enable automatic detection of remote monitoring the overload vehicles. Maybe some autos will be there, overload autos, the children, kids, or maybe the vehicles are there. If you want to inform to the parties, then definitely you can make sure the process has any uniqueness or not there, you have to find out. Okay, now another part of this, another is like multi-purpose card. Like in the same card, we can have access any type of certificate over there. Now, how you are going to apply with the help of the cloud, the mobile, and the IoT, how you are going to doing that is very important. This is how the card will works together. And when this another invention, it's talking about the find outing the alcoholic purpose, find outing this alcoholic of way. Minute. Right. So alcoholic of this person, like for example, somebody, maybe your guardians or maybe your relatives or even your family members, or call through a call that in the night times, and to identifying whether that person is alcoholic, how much they have taken the alcohol, whether we want to be protect them, we want to be bring to the home in a safe way, to know directly through that how we can be identify whether his person is alcohol or not. Through the phone itself, we can be identified. How we can be do? How can we overcome the problems over this? So such type of inventions also be there. Not only this, and we can also have like smart camera where we can monitor. If you try to observe in the figures what they are going to be observing here, we have some the numberings we are going to be giving here. Like so, this is the part where the device consisting. And inside the device, we have some other sensors, some other parts are available. And here in the cloud, we have some other parts. Again, there is a report form. There is another numbering. So this numbering, that's what we are saying when we are talking about the abstract of a patent. They can mention the numbers, so on, so in the brackets, the numbers, right? So like how we can be make in this process, how it is going to be monitoring that with the help of smart camera. It is only one device. Inside the device, we have compresses with all the different sensors, compresses with all the different devices over there. So such type of things also we can done it. So not only this, we can also have a wearable protective device. Like we can have a wearable protective device over here. With the help of this device, inside that is compressed with all this. It is compressing with all this. Now, what are these advantages? How it will work? It is another topic. It is available in patent office. You can access all this my patents over there. So wearable protective device is also be another patentable work. And another we can talk automotive system. Like as I said you, how we are making this auto powered assisted devices. Like here is a stick. Inside the stick in the bottom, we are going to be making our inventory step. So this is where the device microcontroller is available. From there, the forces, how the energy is storing in the help of the battery. Here is the battery is available here. Now how it will be done the process. That also be a inventive step. Like already I had told you that there is no time to explain each and every patent. Just I want to be go in a faster way. Now this is another smart travel system for guiding visually impaired people. This is like as a specs type of that for visually impaired people. Now where we can add all different sensors where we can for monitoring. Now the product will look like not only like this, it also be look like other part of this product is. This is how in each glass of the frame, in each frame of that, how we are going to be adding the sensors, how they are going to be protecting. And with the help of not only the specs, we can need another external devices like mobile to store the data, to access the cloud, to access the internet, to make sure some other things. So with the help of the specs also, we can make some inventive things of this. So not only this, we can have a lot of the other things also be there. So that's about some of the inventive steps, what we are going to discussing about this. Right. Next part we are going to discussing about the digital signatures. Digital signature. Now there is a question among you all that when we go for e-filing, when you want to go for e-filing, definitely we need digital signature. So I'll show you in the camera. This or the digital signature is available, like in the form of a pen drive. Pen drive is called as digital signature. Digital signature is not like signing on a white paper, make a photograph, crop it. It is not digital signature. It is a scanned signature. It is not digital. Digital signature is in the form of a pen drive. It will become. So we have to apply from the third parties. Like in the left-hand side, there is a third parties. Most of they are preferring for the eMudra. They are going to be. This eMudra have company or other encode solutions also be there. The third parties where they are providing the digital signature. So they are providing, before going to applying that one, they will take all the details. They will take your Aadhaar number, the PAN numbers, the address proofs, and your voice recording, video recording, your scanned signatures, everything they will take from you and they will be embedded all the details in this signature, and they will have to use some sort of procedure how to connect that. So once you can connect it, you need to file. When you are going for e-filing, we have to sign all the documents with the help of this pen drive, that is with the help of digital signature. If you are for definitely for e-filing, digital signature is mandatory. Any one of the inventor, not all the inventors have the digital signature. Any one of the inventor or any one of the applicant have the digital signature, then it will be allowable in the e-filing. Okay. And coming to the complete specification, as I said, what are the things are there? They're having the title, and they're having some sort of the complete specification inside that. Inside there is a names of the inventors, applicants, and preferable of the description. And not only this, they're also having, I'll show with example so that we can understand clearly. The title of the invention, field of the invention, prior art, the objects in the sense, objects of the invention, summary, detailed description, drawings, all will be there in that. And very shortly, I will tell you, you can draw the drawings, how I have just now shown with the help of some numberings. The title should be minimum 15 words. The abstract should be 150 words. These are the some of the things are there where we have to take some precautions before going to that. Okay. And other sections as abstract, best methods also be available. Okay. Now, will we see that we are having three types of claims. Most of us, to grant a patent, you are thinking that my documentation is good, but they will look mainly on claims. They will grant you your patent based on only your claims only. If the claims are not good, then definitely there is a waste of the efforts what you are putting. The three types of claims we had to be written. One is the preamble, transitionable, and the body, where the preamble is going to talking about introductory phase. For example, I will show you one example here. An apparatus, there is apparatus for cooking rice, compressing, a means of holding rice, a heater configured to get rice to the rice holding means. This is called as the preamble, introductory. The first claim must and should be the novelty. When you are writing on a patent, the first claim must and should be is a novelty. That is called as preamble. Means protecting your invention, how you are protecting. That clearly mentioned in the first claim itself. The second onwards, you can start writing with the transition phase, where a word phrases such as compressing, including, consisting essentially of, such type of words we had to be used in the claims. And the third, the body. The body is nothing but portion, where actually where the device or the process or the product, how we are going to talking about that. Like introductory, transition, the body. If all the three phases will combine, then based on that only the patent will be granted or may not be granted. This is one example. Another example, see, a device compressing with a pencil and a light attached to that pencil, where a device is talking about introductory, a pencil compressing with talking about the is a transition. The third, which is going to be highlighting, compressing of that, including, making as transition phase, right? All that phrases has to be added, including over there. Then only you can make as a patentable, or simply just write down as the proposed work is there. This is so and so there, right? It's not like it's a good way to write it. Now I will show you some samples of that one. Very important conclusions of my presentation will end after discussion of this. We'll see now another 15 minutes now. Another 20 minutes the presentation is left. Another 15 minutes in the fast track, we'll see the samples of the form 2, how the complete specification will look like. We'll see some samples of the first examination report. We'll see some responses, how we need to be responsive for that one. And we'll show you some international patents, and we'll talk at the last some do's and don't do's. Let me have patience for another 15 minutes with us, bear with me. Now let me talk about the sample forms. Now, before going to that one, let me see, for example, when you want to be search the patents, this is my name, where I'm searching in my WIPO database, patentscope.wipo database. I have said you right, one of the international open access database. When you want to try to search with my name over here in the WIPO, it automatically showing all the patents which I have with the combination. Say, for example, I'll just refresh the page. This long back is open. check it out. So already is there. I'm just click on the search. When I click on this search, see the results is a total 13 patents is showing. It is showing over there, where it is highlighted from the inventors, the highlighted things. So this is contactless self-etiquette system, auto-powered assisted system, the monitoring tool for the software mistake proofing quality software, internet-based of multi-purpose share, dustbin management, and also have the automatic detection remote of overloading, the IoT enabled gateway for LED detection, and visually impaired people for a smart travel assistant device for visually impaired people, where protective device with IoT monitoring and identification of missing person, which is missing person to make with the help of deep learning approaches. And also in the second page, another patents are available. Like when you want to be searched when in the databases, you can search with the name of the inventor, name of the applicant, or with the having with the titles already has shown you how to search for that. And also in the patent, Google patent also, there is a queries. Like when you want to search for Internet of Things, when you are search in the left-hand side, if you are observing the Google patent, there is a query pattern, search trunks are there, like and or date of patent filing, date of publication, date of the grant only. If you filter this query, you can get at the right-hand side, the exact relevant, at the left-hand side, exact relevant things are there. In the same fashion, when you are searching in the eSpace net also, you can go for the advanced search. In the advanced search, at the left-hand side, it is having the query, like and or fields are there. You can add any number of things. You can plan your query, like we have just now seen in the class patent processing search, like in the last step, sixth step, query is a big one. You can have to paste every part of that in this query search so that you can get it very relevant of the things. And not only that, you can also search in the patent office, like here in the patent database. So here is the InPass. This is the InPass website, where it consisting of the different fields, like with the inventor, with the title, with the abstract, with the application number, with the patent number, with the or maybe application number, inventor name, inventor country, applicant name, inventor address, filing office, all with the different queries are there. Here we can enter the captcha and search it. Like this, you can search with this one. Okay. And coming to the sample, the first one is the sample, as I said you, sample form. Like I will show you two different samples of my patents, how we are filed it, just for your better getting of knowledge. So see here, this is a form to look like as a complete specification. This is a title and followed by the applicants, whomever the applicants want, you can add over here the applicants, followed by the field of the invention, followed by the background of the invention, that is nothing but prior art, object of the invention, summary of the invention, deep description of the drawings, detailed description of the invention. Like these are the numbers how we are going to representing. And claims, see the claim itself, the first claim itself talking about as per the style of the three phases of the claim, the preamble, transition, and the body. So a system which is integrated with the user variable protective device compressing of these are the things. Like after that, how each device, how each part of the device, how each of the sensors or how each of the things, sub things are going to working. You can talk from the climb one, how the climb to work, how from the climb one, how the climb to, 3 will work. Like it is a continuation process. In detail about that, we have to be write it. The abstract followed by the drawings. See the drawings, how it will look like. Here, the drawings has mentioned very clearly. Total head is not my patent, including the head is not my patent. Only the part where I am going to be adding by that protective device, that device that has to give the number. Clearly mention what 100 indicates, 110 indicates. That's why I said entire system, if you are consisting in a laptop, entire is not your inventive step. You can add it something that is there for, but where you are adding the device, you have to mention that entire system, specify each pieces, divide that figure into pieces, talk about each piece and which piece belongs to your invention, that has to be mentioned clearly. And inside that, again, in the figure, we have like this, the number, the 110 means 110 indicates like this. I have said roughly in the first level of DFD, data flow diagram, I have mentioned, this is how the figure look like, the device look like. Again, there is a 100, 110. Now, how the 110 look like? Again, there is a 111, 112, 130. How it will look like? Again, if there is any description, any detail about the 130, you can make sure this is again 130. How, what is there in 130? This is a 300. Inside that is a temperature sensor or ultrasonic sensor, display screen, some cloud or buzzer, something. You have to talk in detail about one after the other. This is one sample of a complete specification. Let me see one more sample, verbal sample of the form 2, how it look like. This is another invention. This is an invention title, a hand-warm real-time smart navigation device useful for the blind and visually challenged people. So this is the title and field of invention, background of the invention. Just look off the draft, how it is going to be having. Object of the invention, summary of the invention, brief description of the drawings. This is a description over for the drawings. These are the claims. This is a smart navigation device for blindly visual people, compressing of this all the things are available. So nearly it is drafting 8 to 9 claims. This is abstract, and these are the drawings for that. So look like the device is like this, and after that again the device sub device is this is figure 2, and figure 3 talks about again like this. Figure 4 talk about how it will works. Figure 5 talks about how it is. The last figure talks about the procedure of that, how it is going to be doing. So in detail of everything has to be done clearly over that. Okay. Now the second part of the presentation, what I have said you in this FERs. Now let me see some FERs. So till now we have done 11 the 10 internet patents. Out of that we got the 7 FERs reports of that one. Still waiting for 3 other. We have responded nearly 4 FERs, and including mine, that is totally 5 responses have done it. Let me have take one sample. These are the different FERs for getting of that my inventions. Let me have a sample of this. This is how the FER report look like, which is get from patent office. Now this is the patent office, like this is so and so Bashir, so and so, associate professor, department of so and so, Sridhaniketan, and on that name of that they have signed the control of patent. Vijay Singh has sent the report. Now what the report talks about? This is the examination report, when they have filed, what is the application number, when the date of filing, and who have filed, who are the inventors, and what is the examination date we have applied. And summary of the report, we have climbed 1 to 6, whether it is a novelty is there or not. Yes. Any inventive step is there or not. Yes. Any industrial applicability is there. Yes. The clarity of consistency is there. Is the clarity? Yes. And some clarity is missing in the claims 1 to 6. And what are the technical details? The second part is talking about technical report, talking any patent related literature. This invention is matching to any patents, already existing patents. Yes, it is matching. They are saying to which one is D1, D2. They are mentioning, and they are saying it is a matching. No, we have to define. D1 is like the invention is going to like this. My invention is like this. We have to define properly how D1 is different to my invention, how D2 reference is different to my invention. Non-patentable literature, like any journals, conferences, forum, blogs, there is no non-patentable such as match with my invention. What are the inventive steps? These are the inventive steps 1 to 6. But in 1 to 6, they are saying like this. So we have to define their D1 is talking discloses like this, but it is different for the D1, different from D2. How? That difference you have to be clearly mentioned in the response. Each part we have to mention it. And sufficient of disclosures, yes, they have done it. Clarity and the consistency of this one, 1 to 6, the claims. Somewhere they are going to using avoid A, we have to use only not used to and, we have to use A. And date of signature, in some of the forms, any signature is missing, or form 3. For there is a very important point that once you file your patent, it's published, go for examination. For every 6 months, you have to be apply for form 3. It's a free form. You have to apply the form 3. What is a form 3? Undertaking form. We had to be tell to the patent office that we are working. The patent still live. The patent, whatever we have applied, we are working on that. Still, we are going to working on that one. We have to say, we have to confirm to the patent office for every 6 months, we have to apply form 3. If you're not apply that, they indirectly think. There is a indirectly think that something is happening for that patent. They have filed it, they left it. They forgot about that one. They think like that. So any other deficiencies are there? So we have applied, this is for early examination under the female category. So proof of that same has to be submitted in the form of hard copy. So when we have filed in this one 2020 August, and when we got this is request for examination and got the request for examination, the same we have applied for that. So within 45 days you'll get it. And who the examiner of mines is Vijay Singh from Delhi. So when we had to submit on or before, as I said you, 6 months. So they have got within the 6 months we have to respond it. So already we have responded for this report. Now, how the sample of the response report? Let me have seen that also. The sample of that report, we have to submit any amendments, any changes. If you want to do that amendment changes also, you can do it. The response will be look like this. We have to give the response in this style. The response is like with the application number, for 21st January, the patent office, we are going to be giving to the attention of Vijay Singh, and who are the inventors, what is the title, what is the letter references, so on, so on. So this is a covering letter. Now followed by, for each section of the FER, for each section, whatever they're talking about in the documentation, for each section, the detailed technical report, like D1, D2, they are referring. Non-patentable, no. So inventive steps, they are referring reference D1. So how reference D1 is different than me? We have to explain clearly. So the reference D1 is doing like this, but our invention is differs from so on. So like clearly have to explain reference D2, how it is different. Now based on the reference to how my invention has differing. And each section, this section already we have seen, right? Sufficient of disclosure. For each section, we have to make comment of that. So clarity and consistent. So I'm going to be making some amendments in the climb 1. We can also amend it, currently amended. Amended means we can change it. Currently it is amending of this. We can change based on the comments from the examiner also. There is a chance to allow for changes the abstract, changes the title, changes the description, changing some drawings, changing some, not entirely change. Small changes up to some limit, it will be allowable. Okay, and finally we can give some conclusion how it will be different. So this is how we have to be respond for that FER. Okay, so as I said, FER sample form 2s we have seen some FERs and their responses. And what is the next part of that is in our presentation, FER responses. Yes, international patents. Now coming to this part. In another 5 minutes, I'm closing my session. International patents. International patents is here. Blindly, we are going frequently we are seeing that there is a boom. We can say there is a very buzzword that Australian patents. Why? I don't know why the peoples or most of the peoples we are going to for Australian patents. How it is related? How they are giving simply granted? What is the meaning of the procedure normally for getting a grant? First, we had to file the first step. Second, publication. We had to go for that, publish of that. Patent office will publish. After that, it goes for examination. Once it goes for examination, the examiner will send a FER, first examination report. We had to respond for that response. If it is satisfied by the examiner, satisfied by the patent office, then we'll get the grant. This is the normal procedure in any country, not only here in India. In any country, this is a procedure. Now, simply by applying that patent, immediately we are getting grant. Even the Australian patents is publishing. Filing, publish, grant. Which step is missing here? Examination. If you want to climb as a grant, if you want to make it as a commercialize, if you want to go for a sold to that any third parties, sold to for any companies, then definitely we have to apply for examination. Unless it not be examined, will not make it as a patented. When we can call as patented? When it is a commercialized only, there is a patent. When you are writing and publishing a paper, if nobody is using that, nobody is citing in their work, your published journal or published conference, what is the use of that journal? What is the use of that conference? In the same fashion, when you are making a grant, when you are making a patentable, definitely it should be a commercialized. Unless it's not a commercialized, what is the need of the patent? Only for our developing of the CV, only for the purpose of NAC, for the purpose of NBA, for the purpose of the NIRF? No, we have to build, we are making. And sometimes we are going to observing that some WhatsApp groups and some Telegram groups are available where we are going to be seeing that one. First position is available, 7th position is available, 3rd position is available. What is this position? Whether it is a positions of corona patient hospital details, like 7 beds are empty, 7th bed is kali, and oxygen, 7 oxygens are available. What is this of type of business? How you are going to be? Whether if you want to act as an inventor, act as an applicant, definitely we have to make some contribution over there. Unless it is not contributed, how we can be claimed at that? Even in your busy schedule, because of our academic works, because of in administrative work, it just depends on other. If you are observing every patent, really 7 people or up to 10 people, you can go ahead, no problem. But 10 people really they're involved, really they're having. First of all, nowadays, if you see some of the patents, it look like as a national journals also, national conferences also look like as a patent, a hybrid approach for so and so. What is the title? How it will be? Hybrid approach is not a patentable. This is not at all a patentable. When you are talking about a method or an algorithm over there, it's not a patentable. Definitely it should be a process or a product or at least a device looking of that. Then only can go for patentable, right? And Australian patents, it is going to be having that Australian patents, most of that. When you want to be as an Indian, if you want to apply for any international patent, not only for Australia, maybe for US, Japan, first of all, you have to file that in India. After that, through PCT, you have to apply the international file. In the patent, Australian patent, I will show you that website also very clearly. Very clearly, it is. We are also gone through. We have to check that also. What is this actually? The business is going on. We ourselves has to be gone through. We have applied that also. How they are publishing, how they are granting. We have done that process also. Now I'll show you with a clear idea. This is the patent, Australian patent website, ipaustralian.go.au. That is, AU stands for Australia over here, the website. Here clearly they are mentioning Australian patent. We are not blaming the Australian patent. They are very clear. So different patents are there. Innovation patents are there. Standard patents are there. When you are going to apply for applying for innovation patents, just I will go to the login for the demonstration purpose. We have already said gone through this one to know what is happening inside that one to get the experience. See this Australian patents. When you are going to trying here, now the process entirely they change. They clearly mentioning the patent agent belongs to when you are applying for a patent Australian. The agent should be an Australian or a New Zealand. So see here, when I want to try to apply for IP rights. So they are mentioning apply for IP rights. Here is the patents. Apply for a new Australian patent or an international patent. Apply for Australian patent. Now they're asking inventive details, invention agent details and owner details and patent method. Now start new application. Once you start it, they're asking whether it's a provisional patent or invention patent or standard patent. Go for innovation. Once you select the innovation patent, they're clearly mentioning on the basis of your claims only, they will go for grant. Now once you give the details, so say for example, for only namesake, I'm just giving a title and category. Now observe here, very carefully observe. Those who are planning for Australian patents or in a mood of that, they are giving the category as chemical biotechnology, electrical electronics, mechanical only. Because when we call as innovation, a computer program or a algorithm or a approach will not be as a patentable. They clearly we have to select is a combination of a electronic and computer, the both multidisciplinary. It will go for innovation. It's a multidisciplinary. At least it belongs to a chemical or a biotechnological or electrical, electronic, mechanical. These only the 5 categories they have given. Nowhere they have mentioned any computerized, computer engineering, nowhere any application, anywhere has to not mention. This is already defined. The recent I had to take in the decision. Say for example, select anyone and they're asking for apply for description, apply for claims. Just for recording purpose, just for demo purpose, I'm just making use of this. Just take the description. I'm just dropping here and clients. Just for demo purpose, I'm just doing this. And if you have any abstract, you can click on it will allow you for uploading the abstract and drawings. If you don't have any abstract drawings, it will allow. So based on exclusively the clients. Once it is done, see this is asking who is applying this one. Use my details itself. Click on next. Now they're asking agent details. The entity who have act as a behalf of IP, right? We contact the agent with issue. Clearly, they are mentioning the agent must have an address in Australia or New Zealand and an email ID recorded, email address recorded. They are only can apply. Even though if you can manage with the agent also, even though if you can manage, somebody can have your friends or somebody in that one, you are filing. But unless the patent office not having raised any issues, there is no problem. But if they raise the issues, then definitely there is a problem for type of patents. And once it is granted, okay, for company purpose or file accreditation purpose or for any filing record purpose for developing your CV, you have granted, you got the Australian patent. Now, see, I will show you one certificate clearly to you. I will show you one certificate which shows you clearly. It is clearly mentioning this is a certificate grant of. This is grant of certificate grant, not granted. Granted, patented. grant of. Now here clearly they are mentioning, if you read this statement here, note, this innovation patent can't be enforced unless until it has been examined by the examiner, commissioner of the patent, and a certificate of examination has been issued. Until unless that, it will not be go for a patentable or commercialize. If you want to commercialize, we had to definitely we had to go for that is examination. That is the step which is missing in this one. So keep it in that mind. If you're for the what we say, for the purpose of only you have enthusiastically, you can have for fashion. If you have, you can go for fashion, for only for extra fitting purpose, you can go ahead. But the procedure for applying the Indian Patent Office, there is a documentation is there clearly mentioning what is the guidelines. If you search in the Google Manual of Patent Office, and that neatly mentioned. See, Manual of Patent Office Practice and Procedures, they neatly mentioned a nearly 200 plus pages of documentation, how to do, what to do. And I will show you the international patent procedure, how the Indian patent is going. Now, what is the minimum fees is, I'll just go to the last here itself. All the laws, which law has come under which one, how we need to write the abstract, how we need to write the title, drawings, how to write the claims, everything they are mentioned clearly. And I want to show you that what is the cost for each country when you are applying for international patents. In the this, they neatly mention it. Yeah, here it is. Yes, see, the fees is, here is the fees of that, what to do pre-grant for any international. Yes, here is okay. Here is the fees of yes, got it. See the fees. See, when you want to go for PCT, once it is filed in the India, and again go for international patents. When you go for this, the search fees, where we are going to have the international filing fees of this one, the Australian is both are different. AU 80. It is USD 2053. Nearly it is 1,11,000 is a international fee for 80. For Australia, it is the filing charges is $1,589. It is approximately, it is again 70,000 above. It is up into 70 rupees, right? Canada, $306. Europe, 2053. And this is the Switzerland of this 2095. US in the USD dollars, and for small entities, micro entities. For those who are filing in India, from other countries, they're having the charges of 144. If it is a other than natural person. If the other natural person, it is a $36. These are the respective fees when you want to go for international. Definitely, if you have believe that there is a much stuff is there in my patent, definitely you can go for international patent. Not for only curiosity, you can go for such type of patents. And moreover, the do's and don't do things, the last process of this is you please make sure, I will just conclude my presentation. You please make sure that the patents, whatever you are doing, make sure the guidelines, whatever has shown you. If you search the manual patent practices, if you search in the Google, it'll give the documentation where you can easily study about the how to define the title onwards to what are the different forms are available. Everything, including the fees, are available. Just you can go for that. And manual patent, you can read the document and remember the title, how many number of words are there, for the abstract, how many number of words, what it will be, and make sure the type of international patents, if you are more interested to make as a commercialized, then only can go for international patents. Through the PCT is the right procedure to avoid the legal issues. And most of, if you see, not a conference paper, journal papers, they are going for patent. Just I have patent, I have patent, and check whether once you have filed it, you have to frequently check whether what is the status, whether really it is gone for the publication, whether after the publication gone for examination, whether after the examination whether we got the FER report or not. It is frequently had to check the statuses, because if you have 6 to 7 inventors out there, the main inventors will get the updates, but the rest of the people will not get the updates. So that's why you can search in the INPAS website. If it is an Indian patents, if it is an international patents, if you are filing, you can search in WIPO, WIPO. And please make sure have some contribution, then only can claim, can apply for that one. Okay, and make a you can take the support or guidelines or take the services from other parties, but make sure your idea, if you are unable to write if you have an idea in your minds, if you are unable to write that in the form of a draft, or if you are unable to search in the paid databases or open databases, or if you are unable to apply for that one, initially you can take the support or guidelines or take the paid services from other parties, and you can start working and learn from that. Don't like it is like, don't think that always a lawyer or advocate is required for applying the patent. In court, in the general, normally court, we can defend our case ourselves, or we can put a lawyer, right? See, here also the same case. We can go for attorney, if we can go for through advocate, or we can apply for our own. We can define our own. Because of not knowing that forms, not knowing the terminologies, initially it is a problem. Later onwards, you have to be gain the experiences, then slowly apply for your own. So till now, you can apply with the help of the take the support, or if you have any sort of ideas in with you, come forward collaboratively, we can work with you. And if you want any services, or if you want any guidance of that one in support of all the things in any part of that IP, you can please come forward. Definitely will help you in this respect. And the last but not the least, and make sure don't just blindly add your names. And if you're just blindly add the names, if really it's not an invention, not that, definitely have to face that some stuff of legal issues. Okay, so all the inventors has to commit. And more important point here, there is a 2 roles in the patent in all: inventor, applicant. Inventor having only moral values, whereas applicant having moral values plus entire rights on that patent. So think about that one. Inventor, applicant, 2 roles are there. Inventor means only you will get moral values. You don't have any other rights other than the moral values. Applicant means you have moral values as well as the power on that patent. Means you have, when you want to commercialize, any royalty has to come. If you have an applicant name only, the royalty will come. Other than that, entire rights goes to applicant only. Only the moral rights goes to inventor. Keep it in that mind, and just don't add simply the names. You can add it wherever, the 5th position, 7th position. Moreover, remember one more point, like for the journals, first author, second author, third author, there will be there in the journals priority, but in the patents, all the inventors having the same priorities. There is no difference between first inventor to the last inventor, middle inventor, nothing will be there. All inventors are having the same stage of weightage for all the applicants and for all the inventors. Make this point very clear. Okay, so that's my presentations over there. And the last of this, you please make sure of this is I want to 1 minute I'll have. And this is one of the invention already have studied some chip type of meadows, some of them. And this is the student got the of salary of $1 lakh. Now, what is the specialty? I'm not want to show that chip what it is, but what is the specialty of his, why they are offering $1 lakh of the salary means, don't be have stick on for only one area. You must be have a role of multi-role, multidisciplinary, multi-talented. The student having electronics, they have knowledge, database knowledge, data structure knowledge, management system knowledge, algorithms knowledge, robotics knowledge, all different multiple areas, they are having the knowledge. Because of that only, they are offering a good package over there. And these are some of the things which I need to be talk. And please suggest your student that there is a integrated PhD after the BTech. There is there. Once it is they are completed the BTech, in the final year itself, the top universities, they are offering integrated PhD. For this, they will get the stay fund for every month is 70,000. It depends on the university 70,000 to 80,000 only stay fund for every 1 month. And also they will get for yearly 2 lakhs of the JRF fellowships also they will get it. More useful. Only they not required any gate, any UGC net is required. Only they will conduct some interview based on that. Before that, they have some sort of work in the research. It will be weightage in the interview. So please suggest your student go for integrated PhD. Every year, September, when they are in the 4-2 and the 4-1, they are having every month, September, October, on our average, they will have the calls from the different universities. And things should be smart, but not the people's. Use the smart devices to do the fast things in a faster way. But don't think that you will be smart. Smart means escaping from the work. And shortage, very short time, you have to done the job. Don't do such type of things. It will be lose your feature. And plagiarism in India, human brains are plagiarism in India is the highest one. So why? Because human brains, whatever the people they are using, only 20%. Because when you think more than the 20%, they will get more headaches. So don't worry, up to 80% we can think about that one. Correction in any discipline, in any division, any department is not allowable. But if the correction is come into the education, definitely it leads to a dangerous science towards the development of India. Definitely corruption is not at all entertained in any department. If it is especially in education, if it is come, definitely there is a dangerous sign towards that. And to want to start any areas work of that, please refer in your area Gartner's Hype Cycle recent years. It will show you the graph which are the topics in that area will be live for the next 2 years, 3 years, or 5 years, 10 years. And look into a nationwide initiative leading India and do some online courses frequently and feel the implementation and start thinking innovatively. Innovatively things, if you want to get it, first of all, small thing also have to be implemented. We can't implement it, will depend on that. Please implement, touch the things. Then only you can feel what actually the invention. Then only you can get some challenges over there. So then only you can find some gaps over there. Until unless just sitting on the system, reading some articles, reading so and so, reading some chit chats, reading that one, reading this one, it will not get any innovative ideas. Definitely, you have to go into the field, go into the ground. We have to implement that one. We have to touch the things. We have to see the issues. Then only you can get some feel. Then only can open up some challenges over there. Work with multidisciplinary areas. Don't fix on that one. Have some membership in IEEE elsewhere, ACM, CSI, some other things to get more. And have a social media other than the WhatsApp, Facebook. Please make a follow-up in the ResearchGate, Twitter, LinkedIn, academic.edu, Scopus, SSR, all this. Always update for every 2 weeks. Update your CV. See such a way that any updates are there in my CV. There for every 2 weeks there is no updates, means you are not in a academic line. So tell your students to apply the internships in the Bennett University. They are offering free internship for every 6 months. And lastly, please follow the scriptures, whatever the region you are having. Maybe you belongs to any regions, follow the scriptures. Maybe follow the Bible if it belongs to regions, or Quran or Vedas, wherever, whatever they have. We have to follow the scripture. Definitely we'll have a bright future. For every problem, there is a solutions over there. For our coolness to get the patience, to think positively, to think in a positive way, definitely the scriptures will give more weightage. Okay, so that's from my end. Thank you once again to the Adi Shankara group of institution peoples. That's from my end. Over to you, Vikramji. Over to you. Any questions?
Thank you, Bashir sir. I would like to. Any questions, sir? Please.
Any questions? You can please unmute or in the chat.
Sir, good afternoon, sir. My name is Nagendra.
Sir, good afternoon, Nagendra, sir.
Sir, I have a small doubt. Whether we go for Australian patent or Indian patent finally? Sir, which one is good?
If you want to, sir, why we are going to patent, first of all, normally for commercialization, no doubt about that. So if you are not having commercializing that one, better to not go for patent at all. Maybe if it's Indian or the Australian, forgot about that. If you are not going for a commercializing, if you are not selling to any MNC companies, what is a patent? An innovation idea. That idea can be used by the people. That's our motive. So instead of you don't have go for commercialization, better go for a journal, better go for a conference. Better go
Okay.
for a book chapter. That is enough, right? No need of all this facing of problem. Okay. And coming to the Indian patent, Australian patent, first priority is for Indian patent. Australian patent neatly in the certificate they are mentioning without the examination, you're not able to commercialize this one. And however, any one of the inventor or applicant should be from Australian or New Zealand, or at least the patent agent from that. When you want to commercialize that one. And one more thing, sir, they will give for only 8 years. And every year you have to pay the maintenance cost. If you not pay the maintenance cost of $100, they will be removed from the database. For only 1 year, it will be available.
Okay.
That's a grant certificate. It's a grant, sir. It's not at all a grant date from a. They're neatly mentioned. They are very clear, sir.
Yeah. Yes.
Misusing of the other parties. If you want really go for Australian, first apply in India. Through PCT, apply for Australian. That's the right procedure.
Okay, sir.
Go for Australian. Okay. Hope you get the answer.
Yeah,
Any
okay,
other
sir.
questions?
Thank
please?
you. Thank you very much, sir. Very informative session. Sir.
Thank you, sir. Thank you.
Thank you. Thank you very much, sir. Very
Yes, sir.
informative session.
Thank you, sir. Please
Thank you,
share the
Vikram
knowledge
Kumar,
with
sir, for
others.
arranging this.
Yeah, great, sir.
Sure,
Please
sir, sure.
share the knowledge with others also. Hope so that they can be get the awareness. Yes, any other questions, please? Even silly questions also allowable. And this is my email ID, Dr. Kk Bashir @gmail.com. And you can mail me at bashir.kk@vidyaniketan.edu, or my numbers 9502 900 970 and 8919195759. Any sort of the guidance or any sort of the service or any sort of the support if you required, or if you want to collaboratively work with us, or if you want any guidelines, definitely come forward. Definitely we are here too. Any other things, please? Any other questions?
I have posted one link in the chat. It's a feedback link. I request all the participants to check once the chart and fill the Google form link. Meanwhile, our speaker will take the questions.
Yes, any other things or there you can post if you are unable to hope it is thing maybe disabled to the participants, I think. No.
Hello, sir.
Yes, sir, please.
Sir, will there be any difference between going for this early examinations and non-early examinations? Will there be, I mean?
Yes, sir. There is a difference of that. See, normal examination will take minimum 1 year to 4 years, sir. Now, if you are yearly waiting, now there is a difference between paid scopus, free scopus. Free scopus, they are taking much time. The paid scopus, what they are doing, they are also just doing the same. They will send for the reviewers, they will do it. But paid scopus is not being that there is a no work in that one. There is a perception in most of the minds. Maybe for SCA also, there is a paid SCA journals out there, free SCA journals out there. What is the difference between that two? Time. If you want to be a fast tracker, if you want to do it, then definitely we'll go for the early examination. Eagerly, if you are confident on your work, confident on that one, even though if you're not confident also, eagerly if you want to know the FER, first examination report, comments from the examiner, you can go for early examination. Early examination constant is 3 conditions has to be any one of the conditions satisfied. One is women, any one of the inventor should be women, or you are belongs to any one of the inventor is small entity. Any one of the inventor or applicant is a small entity, startup company. Or third one, already you are applied for PCT. This Indian patent already are applied for PCT, then you can apply for early examination. In this, any one of the 3 cases is matched, then you can go for early examination. Not simply all the inventors are gents, all the inventors are male or there. If no small entity is there, no, your patent is not applied for PCT, you are not eligible for apply for early examination. Hope you
Thank you so much. That was very informative information.
Thank you, sir. Thank you. Yes, any other question?
Please.
We'll wait for another 1 minute.
Yeah.
You can unmute or you can post your question in chat box also. If you're unable to ask maybe mic problem or anything, you can post your question in the chat box. So if not, once again, I thank you everyone for your patience, for everything. Yes, Muhammad Akbar sir.
Well, if,
Is there
sir,
Yeah, if there is no question.
Sir, can you hear me, sir?
Yeah, sir. Please, sir. Go ahead, Akbar.
Akbar, please proceed, sir.
Sir, the information is very excellent and informative.
Thank you, sir. Thank you very much.
Sir, one small doubt is that there is so many rumors among and some other rumors, doubts that once we file the patent, we have so many people in the list, like we can increase to number of people. If the grants are received to the people, then how the grants will be distributed, and will the same others with the same preference or will?
Yeah, I got your question, sir. I got your question, sir. The once the grant is nothing but grant means it is not any amount, sir.
Sir.
Like we are applying for proposals, UGC proposals or any other DST proposals. It is not a grant means any amount.
Okay.
Grant means is a certificate, like is a PhD certificate.
Okay.
Only that certificate. That certificate is in that they mention inventors, applicants, title, everything.
Yeah, I saw that one, sir. But
Yeah, that's no, not only the Australian, even the Indian patent also the same.
Okay.
Now the question for coming to your question, how they are distributed means once it is commercialized,
Sir.
once they are going to be commercialized, whoever the applicants are there, in that applicants, the royalty will be distributed based on the understanding of the all the applicants, not the inventors. If the inventors are same as applicant, no problem. That is not a question. It's not a big question deal.
Okay.
Once it is commercialized, all the applicants have the same type of royalty. If it is sold, for example, for 5 lakhs, for example, one patent grant has sold out for any company for 5 lakhs. If the number of inventors are 5 divided by 5, each one will get the royalty of 1 lakh.
Okay, sir.
All are equal priorities. Yes, sir.
One
Please go
more
ahead.
question, sir. Like in journals, we have the points regarding the first author. We have the more points for second
Yes,
author. Like that, is there any feature in the patent?
No, not at all, sir. Not at all like that.
We
If you have patent or not, yes, it is a patent. Whatever the API score for that, you will be get it. They will have a category that filed, published, grant. This is 3 steps are there.
Okay.
Now, actually, filed grants are 2 steps only for most of the accreditations. Now, new one added that published,
Okay.
filed, published, grant. For filing, 1 mark. If it is a published, 2 marks. If it is a grant, 3 marks. That's all. Not more than that. Any maximum to maximum for the grant, 5 marks, sir. Maximum to maximum for the patent file is 2 marks for any accreditations. Not more than that. In any universities, posters, or any other, it is maximum to maximum that much.
Okay, sir. Thank
For
you.
applying for awards, some paid awards is there, right? Some type of paid award in there, they are defining their own 10 marks, 20 marks for each patent like that.
Sir, I even heard that there is some difference between the paid journals and the free journals,
Yes, sir, definitely.
but the process is same. And the
Process is same. Paid in the sense, meaning normally paid is nothing but what, sir? Open access,
Yes, sir.
free access.
Okay.
Not open access, paid access. Open access, when will get? When you pay and publish it. Now, actually, why they are having the credentials for to download the IEEE papers or ACM papers? Because we had to purchase that journal, like $3 or $10 for that. Why there is a revenue of their journals, the journal databases. Why they are IEEE or ACM they're publishing with a free? Is there any mental for them? No. Well, how they are getting revenue generation? Whenever any paper is required from that published in their transaction paper, they are charging. That charge is their revenue generation. If you are not, because of that, the author having losing their citations. To avoid that one, most of they are going for open access. Once you go for paid that general, that is in open access, anybody can access freely, so that your number of citations can be improved. That is only the difference. If you have any restriction, then there is a problem.
Thank you very much for clarifying the doubts.
Right. Thank you.
Can I get the slides from your side to the?
Yes, sir. I will share with the organizer, Dr. Vikram. I will share with him. I definitely will share with you.
Thank you very much, sir.
Yes, sir. Any other doubts, please?
Hello.
Yes,
Sir,
please.
Bashir, sir, small doubt, sir. Sorry for it.
Yes, sir. Yeah, no issues.
Sir,
Thank you, sir. Please go ahead.
actually, we published one of the patent in 2019, sir. Actually,
Okay.
they published the wrong, sir. Title is same, but the description is by mistake. I think it is there. I approached them so many times, sir. Still, it is not changed, sir. What we can do?
To whom you approach, sir?
Sir, you understand my point?
Yeah, I got your point, sir.
The same
Title is
thing,
same, the
patent
description
office.
is
Yeah.
patent office. So amendment will
Yes,
not be
sir,
allowed.
it is, I think
Yes,
it is-
sir. It is called as amendment, sir. Amendment will not be allow you until unless you
Yeah.
got the FER, first examination report, until unless they will not
Okay.
change anything. Once you apply it
Hmm.
for patent, once it is published, it goes for examination. It will freeze until unless you'll get the FER. Once you'll get the FER, that will be unfreeze. At the time of
Okay.
FER, when you are responding to that first examination report based on the comments raised by the examiner, at that time you can go for amendment. See here, the description is going to be amending. Amending in the sense I am changing. This is the
Okay.
change. Because what reason you are changing, that's not a matter. But why you are going to
Hmm.
changing, you can, based on the comments, you can amend it. You can amend the title, you can amend the abstract, you can amend the claims, you can amend the drawing, you can amend the description. Everything you can amend it up to some limit of time, limit of thing. Hope you
Yeah,
get the
okay,
answer.
okay. Thank you, sir. Thank you.
To get the FER, we need to go for examination, sir. Without examination, we can't get FER. Am I right, sir?
Oh,
No,
okay, sir.
sir, I think it is gone for examination, sir. Still in the publication stage. You see, please, the status of the application. Once you enter into the in-pass application number, see the status under examination. Under examination, then it is a under examination. The status it just show. You please check it out, sir. If it is examination only, you will get the FER. Until unless you can't apply for examination, still it is only in the publication stage, will not be go for. Most of the third parties, they are doing that. They will say you will publish within the 2 weeks, it will publish within 2 weeks. They will publish it and they will forget about that. So who will apply the examination? Until unless you can't apply the examination, they will be sort of 2 to 3 years will time. Once it is not applied for examination, they will be abandoned. It will be deleted from the database. They will reject the amendment. It is abandoned from that. Okay, so please check it out. That also is happening for most of the applications. We have seen that.
Okay,
most of the
sir.
FERs are getting, but most of them are not responding because somewhere in the 2 years back or 3 years they are published it and they are in the CV they file it, do it after any committee has came or any other purpose of you're applying for any jobs or anything. At the time, oh, I have a patent, I have so on, so I need to check the status. Like this, you're doing. That's why I'm saying for every 2 weeks or 3 weeks, please check it out the statuses, and please be aware of that parties. We have the G9. If you really, because of time permits, you are not able to contribute. If you really want to be taking off some anything, you please assure take the title abstract and read out whether it's suitable for your research area. If it is good, then you can proceed it. In some cases, worst cases, not in best average cases. Yes, any other questions, please? So if you have any other questions, you please drop me mail. Here is the mail IDs.
Sir,
Yes.
excuse me, sir.
Yes, sir.
This is yeah, sir. This is related to research work. Actually, I am a researcher and just registered my PhD.
Yes, sir. Please.
So, if I want to know my suppose my title will be there. Regarding my title, present work is going on in different what we call different the same topic. Present at what status it is going to be at what present it is going on in that particular topic research. So can I know the status in the any websites?
Yes, sir. Yes, sir. Here one thing as I said you in one of
as you have landscape something, you saw that one in patent something like likewise. Yeah,
I'll just go get back to you. And here is a one line, that is Gartner's hype cycle. This is one, sir, Gartner's hype cycle. And second one, what is the work is going on? As I show you that patent office in here in eSpaceNet. In eSpaceNet, you can go for the classification search. In the classification search, there is your area and sub areas, and select and see that the subcategories. I have shown you A class, B subclass, B group, right? That subgroups, if you are increasing, there you can find out in eSpaceNet. And one more, in the patent in-pass, in the in-pass website, here, if you search for with your different queries in title, see here, there is a title, title field, title, here, title. By with the help of different titles, you give it, you'll get a different things. And also in WIPO, you can search it for the different titles. And worst case, you can go for patent, Google patent. Most of this, you'll get the updated line of work, whether you are going in a right manner, any inputs, any sort of things has to be done or not. Hope you get the answer.
Thank you very much.
Right.
If any questions, please send directly to the Bashir sir email ID, or you
Yeah.
can mail to our college faculty also. It's a very wonderful session and eye-opening session and a fruitful session. I hope each and every participant who has attended this session, they have taken something. And it's Bashir sir has clearly said that how many types of patents is there, what's the trademark, design, copyright, and he said how to search whether our idea is already is there, existing, or it's a novel patent search process. And he said clearly said what is the patent process from filing to granting, both in international wide as well as in India. And he said very clearly about what to do and what not to do. It's very wonderful session, sir. Personally, I'm saying it's very eye-opening and it's very clear-cut session, sir. And I'm thanking all the faculty for the management, the director, principals, all deans of group, HODs, faculty for making the event big success. And personally, I'm thanking you, sir, Bashir, sir, for giving a wonderful
Thank you.
and fruitful session to all the participants, sir. It's
Thank
very
you very
wonderful and interactive session, sir. Thank you.
Thank you.
We hope we see this kind of sessions in future more, sir. Thank
Yeah,
you for
thank you.
all the participants and for the speaker and many once again. Thank you.
Thank you very much. And last request from everyone, please share the knowledge with others also, whatever you have gained it. That's my sincere request. That's my end. Thank you. If any have, please drop a mail or call me. Thank you. Thank you, the management and principal and Vikramji. Thanks a lot to giving me a platform to share my knowledge. Thank you once again for all the participants. Bear with me. Thank you.
Thank you, sir.
Thank you, sir.
Thank you. I'm just sign outing. Thank you.
Thank you. Thank you all. All participants can leave now. Thank you.
Sir, we will get e-certificate regarding this or something.
Have you filled that one, sir? The link which I
Yeah, I have filled. Yes, sir. Yes, sir. I have filled.
If you have done, we will send you, sir.
Thank you. Thank you very much.
Vikram sir, can you please share the video link, sir,
Yes,
for this?
yes. Once the speaker shared to me, I will share to you, sir.
Thank you very much, sir, Vikram sir.
Sir, Sharma sir.
Shall I close the session?
Yeah, please, sir. Already it's recorded, right?
Yeah.
Please, sir. Close.